Welcome to Justice in Two Languages.
Welcome back to Justice in Two Languages with attorney David Idinopulos, founder of Elias Law in Albuquerque, New Mexico. David is a bilingual personal injury attorney who helps New Mexicans understand their rights after sudden injuries, including those that don't happen on the road, but in everyday places like grocery stores, restaurants, and parking lots. I'm Lisa Mosby, and today we're talking about slip and fall injuries in New Mexico. David will go over why these cases are more complicated than people expect and what actually matters when someone gets hurt on someone else's property. David, thanks so much for joining me today.
Thank you for having me, Lisa. I can't believe you guys are having me back, but here we are.
Here we are. David, slip and fall injuries happen in all kinds of places, from big box stores to small neighborhood shops. What kinds of situations do you see most often in New Mexico?
That's a very good question. I will tell you that the short answer is that we see a lot of slip and fall cases that are not really cases. So, for example, somebody will have a slip and fall in a grocery store. They will slip and fall on some kind of wet substance that they encountered in an aisle, and they will contact us and say, "Hey, I had a slip and fall. I slipped on something wet. I want you to sue Walmart. I want you to sue Albertsons, Smiths, etc., etc." Most of those cases are not actually cases. It takes a particular set of circumstances to make a decent slip and fall case, and the vast majority of the calls that we get from clients are not actually cases. Now, when they are cases, they tend to jump out very, very quickly at you. I will give you an example. Years ago, I represented a man who he was actually originally from India. He was Catholic, and he went to Mass twice weekly to attend Mass. And during the Mass, he decided to step out to use the bathroom. He goes into the bathroom, and he falls into a 6-foot pit. One of the maintenance men at the Catholic Church had decided that he was going to work on the pipes in the bathroom during Mass. There was no sign up that said, "Hey, don't use this bathroom," nothing that said, "Beware, there's an open pit." And so this gentleman literally walked into the bathroom, took one step, and before he could realize what was happening, he had fallen into the 6-foot pit and unfortunately shattered his back. He suffered some really horrific injuries. And what I would say is, there's no one set of circumstances that determines whether or not you have a good slip and fall case or a bad slip and fall case. But when you have a good slip and fall case, it sticks out like a sore thumb.
So, in reality, what tends to matter most when figuring out whether these claims even exist?
Well, you have to go take a look at where the accident happened. I'll give you another example. I had a client who was walking at night in a parking lot, and one of the parking barriers that would normally stop cars from getting too close to the building, one of the parking barriers no longer existed, and instead you just had a piece of rebar sticking up. And of course, in the dark, there's no way you're going to see it whatsoever. She slipped on it. She fell on it. She broke her wrist. Again, it just sticks out to you like a sore thumb. They are just so obvious. The cases that we get the most calls on, that we of course turn down, are the ones that I just described. I slipped on something wet. I don't know what it was. I didn't bother to take a look at it. Those are not cases because it could have been a store patron who spilled something there, and the store had no notice about it. That wet substance on the floor could have existed for 10 seconds before our client encountered it. Those aren't cases. Every case is a little bit different, but when somebody comes to me with a good slip and fall case, I recognize it immediately.
So, evidence can change fast in these cases. Spills get cleaned up, floors dry, signs get moved. What challenges come with proving what the conditions actually were at the time of the incident?
The big challenge is a client who doesn't act on it immediately, who doesn't tell us, "Hey, I had a slip and fall yesterday. Hey, I was tripped by whatever it was that was on the ground." And so by the time we get out there, maybe it's 2 weeks later because the client waited 2 weeks to contact us, the business has potentially cleaned it up. Now, that doesn't mean it's not a case, but it does mean that we were not notified quickly enough to obtain the evidence. I have a standing rule in my office that when a client comes in on a slip and fall case, I am to be notified immediately because I will literally jump in my car and drive to the place where this accident happened so that I can try to do whatever I can do to preserve the evidence. And that means taking photos. Sometimes the business owners don't want you on their property, so you have to surreptitiously sort of quickly take photos. Sometimes you don't want to be seen using a tape measure because that's so obvious, but you use something that the average human being would recognize and understand. So I'll take a Coke can. If there's some obstruction in a sidewalk that sticks up, I'll take a Coke can and put it next to that obstruction and take a photograph of that. And later on, we can compare it and we can measure it. But we have to be notified immediately of the condition which caused the slip and fall, because businesses are not stupid. When something like that happens, they know that they screwed up and they do whatever they can to very quickly hide the evidence.
Some injuries just don't show up fully until hours or days later. From what you've seen, how does that delay affect the way that a case unfolds?
It affects it because human beings are, contrary to what the insurance industry wants you to believe, human beings, at least American human beings, people living in this country, are generally speaking good people. And most of us are taught, well, you're a little sore, you've got some pain here or there, but you got to go to work, you got to raise the kids, you got to wake up in the morning, you got to do your job. And so a lot of times people will just think, okay, I had a slip and fall. I'm embarrassed. I don't want to make too much of a big deal about it. And so many times, because of that, people don't seek medical attention. They don't think to call a lawyer. And then they realize after a week or so, gosh, I'm still miserable. I'm still hurting. Maybe something more serious is going on. And because of that delay, we've lost time that we could have used to take photographs of the scene, to get witness statements. In some cases, clients don't even bother to make an incident report, again, because they're embarrassed, and also because human beings are basically good people. Okay, I fell down. No big deal. I'm not that badly hurt. I'm not going to do anything. And then a week or so later, they find out, hey, there was, they've got a wrist fracture, that the pain just did not go away, or they've got a herniated disc or something like that.
And stores and property owners often have their own versions of what happened, I'm sure. What kinds of disagreements come up between their accounts and what the injured person experienced?
Huge. There's a world of difference. First of all, in many cases, we are not even able to get the incident report. We will request it, and this is particularly true for big box retailers. But we will contact the big box retailer and we'll say our client had an accident, had a slip and fall on your property. We'd like to get a copy of the incident report. They say no, no, no. We can't give you that. It's proprietary. It's a work product. We're not going to give that to you. And so we get the incident report 6 months later because we have filed suit. And as it turns out, it contains an entirely different set of facts than the ones that our client related. And there's nothing that we can do to correct the incident report per se, because it's been 6 months and our client didn't have the opportunity to throw in the fact that she came around the corner, there was no notice, there was somebody cleaning the floor, but they didn't put a sign up. Things like that happen constantly, particularly with big box retailers.
And then for Spanish speaking families, reporting an incident or filling out paperwork can be stressful. What kinds of issues come up when language becomes another barrier?
All kinds of issues. We're in the Southwest. We're in Albuquerque, New Mexico, and there is a large Spanish-speaking population in Albuquerque and in many other cities, obviously in the Southwest. So that there is usually a store employee available who will be able to translate what a client is saying, but something always gets lost. Translating is not a word for word translation. There is some art to translating. So, for example, the Spanish word for getting down out of your car is bajar, but bajar can be translated in different ways. So there is an art to translating as well. And the other thing is, when it is not in a client's own words, when you're filtering it through somebody and that somebody is not a professional translator, what ultimately will go in the incident report is what the translator sort of feels like was important to him or her at that time of translating. And that may not actually be exactly what comes out of the mouth of the person who was injured.
I have a side topic here, and that is if you didn't file right away, is there an option to go back and file a claim a week 2 weeks, a month later? What are the options in these cases?
It all depends. That's a very good question. It all depends. There is no law that says a store has to take an incident report when you tell them that you have been injured. There's no law, there's no statute, there's nothing like that. In general, in my opinion, it's good policy of the store, particularly because, as I've said, many of these situations are not actually cases. But you cannot walk into a store and demand that the store take an incident report and have that incident report written down on a piece of paper. So it presents some problems when you have smaller establishments, particularly bars and restaurants and things like that. There may be no established procedure whatsoever to take an incident report. And what I tell people is write your own incident report. Let's review it. Let's put in there the information that is important. We will send that to the restaurant or the bar or wherever it is that you had your accident. We will keep a copy of that, and you will create your incident report. And believe it or not, even sometimes in big box retailers, you won't be able to find the manager. The assistant manager will be on break or something like that. And so the store personnel are making it up as they go along. And sometimes they'll just have you write down what happened on a piece of paper, put your name on there, put your phone number on there, and that's the incident report.
And I want to talk about parking lots. They come with their own set of problems. You'd mentioned one case with a woman involving an incident in a parking lot, like uneven pavement, poor lighting, or changes in weather. I'm particularly thinking about ice. What makes outdoor cases different from those indoor cases?
Outdoor cases, more than anything else, depend on common sense. And what I tell people all the time, what I tell people in my office, what I tell clients is a slip and fall case in a parking lot has to pass the smell test. You got to be able to look at the condition which caused the fall and basically say to yourself, is a jury going to buy this? Is a jury going to say this was an unreasonable condition which the premises owner had control over and should have fixed? Or was this, there's a little crack in the pavement, but obviously, every pavement is going to have a crack here or there. I had a case once with a parking lot case of a motel, and a woman checked in at night, and there was a massive pothole right next to her car. But for whatever reason, when she checked in at night, she was able to avoid the pothole. She goes, she checks in, gets her room. She decides that she's going to go back out to her car to retrieve something. She steps in that massive pothole, breaks her ankle. That's one that passes the smell test, because if you look around, you can tell, look, it's a black hole that is exactly situated where people are going to walk because they have to park their car, get out of the car, and walk in this area. There is not much ambient lighting around, so obviously she's not going to see the hole. That kind of thing, that passes the smell test. But a woman who is walking and there's a little crack in the pavement, and she says, my foot got caught in the pavement and I fell down, and she's wearing decent tennis shoes so that there's no real reason for her to get caught in the pavement. That's the kind of thing where I tell a client and I tell the office, look, we will never convince a jury that the parking lot should have been in perfect condition, and we will never convince a jury that single crack caused this person's accident.
Can you speak just briefly about weather? When we have ice or maybe rain that causes a slippery surface, what is the responsible party supposed to do about that? Can they clean it up? Can they keep up on it? Or are there cases that happen because of weather?
Generally speaking, the rule is, does the premises owner act in a reasonable manner to maintain the premises so that it's suitable for foot traffic or whatever business is going on at that location? It starts raining or it starts snowing, and a client has a slip and fall 5 minutes after it starts snowing. I don't think anybody's going to say that the premises owner was unreasonable. On the other hand, if it snowed all night, the business is open the next day, the business is charging folks money to come in to do whatever transaction they are going to do there, and they've made no attempt whatsoever to shovel, they've made no attempt to salt, anything like that. That is the kind of case where you can make the argument that the premises owner is unreasonable. These cases are rarely perfect. There's almost always some level of comparative negligence on the part of the person who is making the claim. Maybe they wore the wrong shoes that day. Maybe wearing Crocs on a snowy day was not the best choice of footwear. So there is some comparative negligence. These cases are often not perfectly clean, but there's usually enough negligence to go around so that we can make a recovery on behalf of a client.
And David, where I want to wrap up today, for listeners who shop, work, or run errands around New Mexico every day, what helps them understand how these cases really work when someone gets hurt on a business property?
What the number one thing that helps them understand how these cases really work is me. Call me. Please call me. The number of cases that I have had where a client has walked into the office months later telling me what happened, and I say, well, you didn't give us a chance to preserve the evidence. We didn't go to the scene. The pothole is now repaired, so I have no idea how deep the pothole is. That piece of rebar that you slipped on or that tripped you, that rebar is gone, and there's no getting it back. So what I tell people all the time, and I think I talked about it in an earlier podcast, is attorneys like me, we turn down more cases than we actually take in. But even when we turn down a case, we will tell a client, this is the reason why it's not a case. And very often the client says, okay, now I know. Now I know that I'm not wasting my time. Now I know that I didn't give up the Willy Wonka gold ticket on a recovery. If you really want to know how the law works and whether or not you have a case, call me. And if you don't call me, call somebody else. There are a million billboards in this town. I used to have them. But call a lawyer and we'll tell you where you stand.
David, thanks so much for your insights today. And that's it for today's episode of Justice in Two Languages. To learn more about attorney David Elias Idinopoulos and his team at Elias Law, visit abogadoelias.com. You'll find resources in English and Spanish to help you understand your rights and feel supported after an unexpected injury. Thank you so much for listening. Don't forget to like, subscribe, and leave a review if you found this episode helpful. And we'll see you next time.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.